Perfect. Then I think we start. So welcome to this International Insolvency Institute and IWIRC panel on the analysis of new insolvency legislation in Europe. I'm very delighted to have 5 very esteemed speakers with us today, who are all part of the NextGen program, the next leadership program of the International Insolvency Institute. And it's great because we have someone from class 1 all the way going to class 10. So I'm very delighted to greet in this point Lynette from the Netherlands, now in the UK, Marta from Spain, Wencke from Germany, Francesca from Italy, and Mylene from France. Just to give you a short overview of the NextGen Leadership Program, it is basically a program for, as it says, the next generation. And with this, we want to ensure that there's also not just a network between professionals, academics, and judges in the III, but also there's a group of people that start connecting from a very early age onwards, who are all part of the cross-border and insolvency framework and arena. And with this, I'm very much looking forward to the discussion we're having today. So thank you very much for the 5 of you that you agreed to speak, and I'm looking forward to your presentation. Thank you.
Thank you. Let me share. Let me share my screen. Welcome all today to this panel discussion. As Annika said, I'm Lynette. I'm an associate in the financial restructuring team at Milbank in London. The idea today is to discuss some recent developments in restructuring and insolvency legislation in a few EU countries, namely France, Italy, Spain, and Germany. We will, for example, discuss where the countries are in implementing the EU restructuring directive and whether COVID accelerated the implementation process. Mylene will discuss the situation in France. Mylene is a partner at Boche-Dobelle, previously worked for Clifford Chance for about 10 years and also as counsel at Auguste Debussy. And she is the founder of the French Women's Restructuring Network. Marta will be discussing the developments in Spain. She's a professor of commercial law at the Universidad Autónoma de Madrid. She has written about 3 books and many papers and book chapters on insolvency law, so she's an expert in the field. Francesca will be discussing the developments in Italy. Francesca is an assistant professor of business law and tourism, accountancy law, and business and digital law at Foscari University in Venice. She is specialized in accountancy, insolvency, and management issues, and also works as a business consultant. And Wencke from Germany. Wencke is an associate at Overy in Frankfurt, where she's a member of the Insolvency and Corporate Law team. Please feel free to use the chat function. Today, I will keep an eye on the chat box, and I'm happy to ask the panel members any questions you may have. And also the slides that are shown here today are also available on the conference website. So please feel free to take a look at the conference website as well. So before we start our panel discussion, I would like to ask the panel members to just introduce their jurisdiction and discuss a few developments in their jurisdiction. And we have prepared a few slides for that. And Mylene, would you like to start?
Yes, sure, with pleasure. Thank you very much, Lynette. Can you hear me well? That's okay?
Yeah.
Yes, great. So as an introduction, you asked us, Lynette, to say a few words about where we are in each of our countries with respect to the introduction of the EU directive on restructuring, as well as a few words about the potential impact of the COVID crisis on the agenda of the introduction of the directive. So as in all other EU member states, the story started a long time ago in France. We go back to May 2019, when the French legislator, the parliament, enacted a law named Pact. That was an action plan. The name was an action plan to support the growth, to support firms, and one of the rules in this law aimed at enabling the government to introduce the directive in the law through an ordinance. So it's like a delegation of power from the parliament to the government to introduce the directive on restructuring preventive frameworks. The laws say that such ordinance should be passed before May 20, 2021, this year. And it means that I think that we have almost reached the end of the story. The draft ordinance has already been prepared by the Ministry of Justice. And I just would like to emphasize the fact that such draft is the result of a very large consultation process of people working in the world of insolvency and restructuring. I understand, for instance, that it has not been the case in Germany, that kind of consultation process. Wencke, you can correct me if needed, but actually I have not seen other consultation processes, and we have been consulted many times. Even since 2018, so even before the law has been enacted. And the last phase of consultation happened a few weeks ago, based on the draft ordinance prepared by the Ministry of Justice. The draft ordinance has been sent to the public or to lawyers, insolvency officers, mainly organizations in the field of restructuring and insolvency. And we were given the possibility, the opportunity to give our position, comments about the plan of the government. This consultation is now over, and so we wait for the ordinance to be passed before the end of May. COVID crisis, what was the impact? I would say that, as contrary to other countries, and I think again about Germany, I don't know if it's the result of the impact of the COVID state, but there has been no acceleration of the introduction process of the directive. My feeling when we had the COVID crisis starting was that, on the contrary, we would be late for the introduction of the EU directive, because the government was so busy drafting dozens, maybe hundreds of other ordinances with respect to the state guarantees, loan, etc., that actually the discussions in consultation process about the ordinance, about the directive, was completely stopped. But finally, we are it. The draft ordinance is ready, and I think we will be on time to have the law enacted pursuant to the agenda. One last comment with respect to the impact of the COVID crisis, and I will get back to these points later. Even if we have already a restructuring proceedings in France, the introduction of the directive was expected to modify our existing regime. And there was also a fear that such modification will introduce a certain level of complexity, and courts, lawyers, insolvency practitioners will need time to get familiar with the new law. And we thought it was not maybe the right moment to pass on a new law. At the same moment, we expect a wave in insolvency proceedings. There has been no wave for the time being, but there is still a question about that.
Thanks, Mylene. The next slide is Italy. So Francesca, would you like to say something?
Thank you so much. And thank you for the opportunity to explain what the situation in Italy concerning this European Union Directive on Insolvency. Italy had for a long time the same Italian bankruptcy law, that is the Royal Decree of March 16 of 1942, number 267. You can see all the decrees and the laws in the slide. At the beginning, we had for a long time this kind of insolvency law, bankruptcy law, and it was, let's say, quite good for the changing of the markets, of the debtors, of the businesses. Then at the beginning, then when it started the new millennium, the doctrine started to think about a changing of the bankruptcy law. And we started the process in 2017 with the law of 2017 number 155 that was delegating to the government the reform of the Italian bankruptcy law. This was the idea for updating the rules of bankruptcy law to nowadays. Then we had finally a legislative decree in 2009 that gave birth to the new insolvency code. This was in the aims of the government, the new law for the distress of companies and of civil debtors, consumers, and so on. The problem was that when this legislative decree has been enacted, part of it came in force in 30 days, and the majority of the provisions of the new insolvency code had to become in force in August of 2020. The problem is that we had the European Directive in June of 2019 that brought a new scope to the legislator, that was the amendment of the new insolvency code of January 2019 to to comply, let's say, with the provisions of the EU directive. That's why in March of 2019, there was a law delegating to the government the adoption of supplementary and amending provisions for the insolvency reform. Then we had the European Directive. It was June of 2019, and it had an impact that I can say it's quite small on the new insolvency code, because the new insolvency code was already complying with some rules that were that you can find even in the recitals of the directive and then in the articles of this directive. That's why in February of 2020, we had finally a draft of the legislative decree for the adoption of this supplementary and amending provision for the insolvency reform. And at the end, the legislative decree came in October, amending the new insolvency code that was meant to be a delay for this new code. And now it is supposed to be enforced for the 1st of September of this year, so 2021. So a long time for having all the rules of this new insolvency code enforced, for the enforcement of it. We will see even later which are the key features, but the main features amending the Italian bankruptcy law of 1942 and complying with the European directive have been the introduction of the early warnings. Early warnings are something of really new for the Italian law, the Italian insolvency law. We wanted to apply them quickly, but the pandemic brought to a new scenario, so it was not possible with that kind of climate to apply all the measures envisaged for these early warnings. And another important thing concerning the European Union directive was the preventive restructuring framework. This framework was quite rich, let's say, in the Italian bankruptcy law that has been amended many times, but not so, not in a really tough way. And so I can say that for the moment, what is really new in the new insolvency code that complies with the rules of the European Union directive is most of all the early warnings that are not applied yet because of the pandemic. So we will see how it's going to be developed, this kind of new insolvency code that for the moment is just on the paper, let's say. Thank you.
Thank you very much, Francesca. I think the next slide is Spain. Yes, Marta, would you like to discuss the situation in Spain?
Yes, thank you, Lynette. Well, first of all, let me say that I am really and truly delighted to share this panel with you guys. And I want to thank the promoters and organizers of this event for the invitation. Now, I think that as I have so little information about the implementation of the directive in Spain, I thought that I will give you some broad context about the restructuring system in Spain. Now, the truth is, we did not have any restructuring measures in Spain at all until 2009. Now, in 2009, the Spanish lawmakers began started a reforming spree, and up to date, we've had 28 reforms of the Spanish insolvency system, and the main reforms, the main aspects of these 28 reforms regarded restructuring and pre-insolvency measures. Now, the current framework in Spain is composed of the following tools that you can see on the slide. We have a stay of enforcement, a moratorium. We have both bilateral and collective refinancing agreements, which main advantage is that they are protected from avoidance actions. And the most popular by far tool are court-confirmed or homologated refinancing agreements, which not only are protected from avoidance actions, but also allow for a cram down. The disadvantage, the main disadvantage is that these homologated refinancing agreements are restricted to a certain kind of creditors, which are financial ones. Public creditors and commercial creditors are left aside. So for the moment in Spain, we do not have a comprehensive tool that allows for a cram down for all kinds of creditors. Now, due to these 28 reforms that we have endured during the last decade, the Spanish authorities considered, and they were right, that we needed a recast, because due to these 28 reforms, several contradictions in the Spanish Insolvency Act had arisen. Of course, if you make 28 reforms, at some point they are not coordinated within themselves. So a recast was approved, came into force in September 2020. This was announced in May 2020, and it was strongly criticized because we were already under lockdown, and as we were the financial crisis due to COVID approaching, it was strongly criticized that the Spanish government decided that a recast came into force. The truth is, this new recast does not add any substantive novelties, any substantive modifications to the pre-existing system. It just clarifies the pre-existing law and has got rid of the contradictions, the internal contradictions. So in my opinion, but I have to admit it's a minority opinion, in my opinion, the recast is to be welcomed. Now, what happens with the directive? A special commission was appointed more than a year ago with the task of drafting the implementation of this directive. The result of this commission is secret, and apparently, and this is some sort of confidential information I've had access to, apparently a first draft was submitted in December to the government, but this first draft has not been made public. So we have no idea of the exact impact of the implementation of the directive. We don't know whether there will be a special tool for SMEs or not. We are in the dark. Nevertheless, I wanted to make a reference to what Mylene said about public consultations. And in Spain, before this special commission was appointed, no public consultation was carried out. So I don't know whether once this first draft comes to light, we will be consulted, or whether the draft will be directly processed by the authorities without any public consultation being done. And as for the impact of COVID on the implementation, I fully share Mylene's impressions. And on the face of it, you would think that the directive should have, the implementation of the directive should have been accelerated due to COVID, since businesses need more than ever restructuring measures, which are flexible, which are accessible. But I think that, as Mylene pointed out for France, I think in Spain, the implementation, if any, it has been delayed due to COVID, because indeed the authorities are busy right now dealing with the special measures which are being implemented and approved to deal with the COVID, rather than to deal with the implementation of the directive. This is my subjective impression. Thank you.
Thank you, Marta. The next slide is Germany. Wencke, would you like to discuss the situation in Germany?
Yes, I'm happy to, and also I'm really honored to be on the panel with you guys, so thanks for the opportunity. So in Germany, the situation is quite different from the other countries we've just heard about, because the German legislator has already implemented the Preventive Restructuring Framework Directive in the Act on the Stabilization and Restructuring Framework for Businesses. It's called the Staruk. So in Germany, we love long words. So this is how we name our acts. The Staruk itself is contained in the Act on the Further Development of Restructuring and Insolvency Law, the San-Ins-Rock. And I believe the Sun-INSFOC has been accelerated at least a little bit due to COVID, because also the Sun-INSFOC does contain COVID-related measures in the acts. So other than in the jurisdictions we've just heard about, this might have accelerated the process indeed a little bit. The Sun-INSFOC primarily acts to implement the EU Restructuring Directive. So the STAROG is its centerpiece. Apart from that, the Sun-INSFOC also adopts various amendments to the commercial code or corporate and civil law aspects. The STAROG itself is a pre-insolvency rescue procedure and combines features of the UK scheme of arrangement and the recently introduced Dutch scheme with the German insolvency plan procedure. We actually have been waiting for this direct scheme quite a while here in Germany, because we have not had a similar proceeding before. The STAROG allows the debtor to implement a restructuring plan outside of formal insolvency proceedings already at an early stage of crisis, and provides the debtor with rather powerful restructuring instruments, especially instruments to overcome obstructing minority creditors, which is, as I said, been long awaited here in Germany. Yeah, so the scheme is, as I already mentioned, already available at an early stage, already if a company is facing imminent illiquidity. So that means if it is highly likely that the debtor will become unable to meet its payment obligations when they fall due within the next 24 months. The scheme, however, is not available if a debtor is already illiquid or over-indebted. The scheme is a self-administration proceedings, meaning that the debtor's management stays in force, and the scheme introduces a restructuring plan, which is voted on by separate classes of creditors. The scheme is also partial collective, meaning the debtor can choose whom to include and whom not. The selection of creditors and the building of the different classes of creditors must, of course, not be random, but must be made according to appropriate criteria. What is really special about the classes of creditors is that a majority of 75% in value can bind a minority within each class. And also, in addition, the court has the power to impose the restructuring plan as a whole on dissenting classes by way of a cross-class cram down. Of course, there are a few prerequisites for that, but such cross-class cram down can be done by the court if the majority of classes have voted in favor for the plan, and the class concerned, so the class which is crammed down, is not put in a worse position than it would have been under an alternative scenario without the restructuring plan. Also, during this DAO scheme, a restructuring officer may be appointed, but I think we will talk about the restructuring officer a little later on. The debtor can also apply for stabilization measures and moratorium within the restructuring plan, but I think we will also cover that during our discussion later on. What is also interesting is that the debtor has the choice between a public proceeding and a private proceeding under the STAROG, meaning that if he chooses the public proceeding, which will be placed in Annex A of the European Insolvency Regulation, that his restructuring plan will be recognized throughout the EU, while if he chooses a private proceeding, the recognition might be a bit harder. So unfortunately, although the STAROG is already in force here in Germany, it has not been included in Annex A as yet, so that might take a little while longer. Yeah, and what is also, I think, worth mentioning is that during the STAROG scheme, the obligation to file for insolvency proceedings is suspended, but the debtor is obliged to immediately notify the restructuring court if he becomes over-indebted or illiquid during such restructuring plan. what also happened during our consultations we had here in Germany, which is that a previous draft of this DIWIRC has included special termination rights for contracts. So the debtor had the possibility to terminate contracts which he did not want to conclude, or which he doesn't want to carry on further. But unfortunately, this possibility has been terminated and was not included in the bill we have right now, which is for us as advisor really unfortunately. We were looking forward to such provision, but it is what it is, and we're still excited to see how this dialogue is going to work out.
Thank you very much, Wencke. Let me end the slideshow so that we can see each other, and I can also see the chat box. My next question is whether you can tell me more about the restructuring rules that were in place kind of before implementation of the restructuring directive. Because Wencke, you said that Germany was kind of waiting a very long time for the new rules to enter into force. So can you tell me more about the framework that was in place before the 1st of January?
Yes, sure. So as I already said, we have not have a national out-of-court restructuring framework. So before, a company had only to choose between formal insolvency proceedings, which always carries the risk that an insolvency administrator is appointed, and the debtors management actually loses its powers. Of course, we do have the self-administration proceedings, but it doesn't mean that if you applied for self-administration proceedings that you will actually be granted them. So that was always a risk. And if you didn't want to file, or if you were not obliged to file for formal insolvency proceedings, you only had the possibility to actually agree with all of your creditors, and there was no possibility at all to cram down obstructing creditors. So we actually had cases where a few obstructing creditors actually terminated the whole restructuring, and our only way out was to apply for insolvency proceedings.
Thank you. And Mylene, how about what's the situation in France?
So in France, it was completely different as in Germany. It was maybe the contrary as in Germany, where we had already restructuring tools, and many actually, and for decades, I would say. My understanding is that France is considered as one of the most debtor-friendly, but also preventive-friendly regime in Europe, maybe in the world. The idea is that the more you anticipate, the better you will restructure your business. So we try to incent debtors to anticipate, to go to courts at the earlier stage possible. And so in France, we have what we call a toolbox with several different proceedings. I don't know if you can share again the PowerPoint. I will not describe all the proceedings we have. No need to do that, but just maybe it will give you an idea of
this
the
one?
range. Yes, this one exactly. So where you can see here, 1, 2, 3, yes, 7 different proceedings here. There are actually more than this. Simplified proceedings, or proceedings made for individual persons only, but here are the main proceedings. And actually you can see that all the ones in green, yellow, and orange can be considered as restructuring proceedings. The green ones are called amicable proceedings. They are mandat ad hoc and conciliation proceedings, and they are very different from the other proceedings, safeguard, rehabilitation, liquidation proceedings that are public formal insolvency proceedings. So mandat ad hoc and conciliation basically are completely confidential frameworks offered to a debtor in order to help him finding a restructuring agreement with his main creditors based on a purely amicable basis. This is purely negotiation, I would say. Negotiation. Maybe the word purely is not correct. It's mainly negotiation under the aegis of the court. So usually we describe them at, as out of court proceedings or semi-judicial proceedings, because the involvement of the court is really very small. The court only appoints a third party mediator, a mandataire ad hoc or conciliator, who will mediate the negotiations, I would say. But there are some tools, legal tools, which are made to enhance discussions, especially grace periods, which are stay of payments and of enforcement action, which can be imposed on a reluctant creditor during the time of conciliation proceedings, but also after conciliation proceedings. So these two proceedings have been reinforced, amended in the context of the COVID crisis in order to be more attractive and to incent debtors to go to court, but to use this tool instead of formal collective proceedings. Beside mandat ad hoc and conciliation, we'll also have safeguard proceedings. Maybe you can go on to the next slide, Lynette. Thank you. Here you have the proceedings. You see mandat ad hoc, but you can also see safeguard. We have many safeguard proceedings, accelerated safeguard and accelerated financial safeguard proceedings. They can be considered as a restructuring proceedings because they are available to solvent debtors only. But as contrary to mandat ad hoc and conciliation, they are public and they are formal legal and judicial proceedings with the rules that we know in all EU member states applicable to insolvency proceedings, i.e. Stay of action, stay of payments, rules related to the continuation of ongoing contracts, disposal of the assets, etc., etc. This is a formal proceeding, I would say. So this is our restructuring toolbox, I would say. And at the beginning, when the draft directive has been prepared by the EU Commission in 2015, 2016, we thought that actually the directive or the French government would decide to amend mandat ad hoc and conciliation proceedings in order to comply with the European requirements. But at the end, now in the current draft, we can see that the proceeding, which will be mainly impacted by the directive, will be safeguard proceeding. So basically, we will not create any new proceeding. We have already many proceedings, but we will amend safeguard proceedings in order to fit, with the requirements of the EU Commission, the EU legislator. Safeguard proceedings will be amended, but also accelerated financial safeguard and accelerated safeguard proceedings. a priori, we will keep our mandat hoc and conciliation unimpacted, except for the purpose of safeguard, because I spoke about the accelerated safeguard, accelerated financial safeguard. They are combination proceedings between conciliation and normal safeguard proceedings. Basically, the safeguard proceedings will be the EU compliant proceedings. So we need to amend these proceedings. And as you can see, there is also rehabilitation proceedings. And the idea of the government is to also amend a little bit rehabilitation proceedings in order to have the regime made coherent with the amendment which will be made for safeguard proceedings.
Thank you very much. Marta, you already said that Spain didn't have a restructuring framework before 2009, but how does the French toolbox compare to the to your current regime in Spain?
Well, I have to say I am puzzled by the complexity of the French restructuring system, and kind of envious also. Well, we have insolvency tools, not so many, and not so complex, but I think they work moderately well enough. But they could be better. So I think that the implementation of the directive will aim at enhancing the effectiveness of these tools. They will add. Of course, I'm speculating because, as I said, I have not had access to the draft implementation. But I think the tools, the pre-existing tools, will be made more flexible, and probably the content of the refinancing agreement will be broader, and probably, I hope so, that the crackdown will be made available not only for financial creditors, but also for public ones and commercial ones. And one thing that also needs clarification in the Spanish pre-insolvency regime are the grounds for challenging a refinancing agreement. Under which grounds can you oppose? Can the holdout creditors oppose to this refinancing agreement? But again, I'll need this the slide, Mylene slides, to study it with time.
And Francesca, how does the framework look? The Italian framework look like? How does it compare to the French toolbox?
Well, the French toolbox of Mylene, I don't know. No, we had some preventive restructuring tools even since I can say since 2005, something of really of reach. So many tools we had in court and out of court restructuring tools. Some were confidential, as the certified recovery plan, that can be even something that is not published on the public registry, that can be just signed by the debtor and maybe just one of his creditors. So something of really highly confidential, that can be something of precious in a moment in which the debtor doesn't want the other creditors know that he is in distress. And then we had and we still have with the new insolvency code something of another semi-judicial tool for preventive restructuring, that is the debt restructuring agreement. The first debt restructuring agreement has been set in 2005, and then we had some amendment to that because we had a new variant, let's say, of this kind of tool. That is the debt agreement with the debt restructuring agreements with financial creditors. And both these procedures are based on negotiations that the debtor has with creditors that represent a certain percentage of his debts, and then they ask for an approval by the court. But before asking to the court approval, you need the debtor needs an expert, an independent expert, to assess the plan, the restructuring plan, so that the court can analyze the restructuring plan, the assessment of the independent expert, and then look at the percentage, for example, of debt that has to be restructured. And at the end, there can be the approval. And then we have the in-court procedure, that is the judicial composition with creditors. That is something that starts already in court. So there's a practitioner appointed by the court that should follow all the steps of the creation of the plan, of the voting for all the creditors involved in the plan. And then you have the approval of the court, and the plan, the judicial composition can be finally implemented. Of course, you can have implementations with the restructuring plans that envisage many years for the payment of the debts. And I can say that more or less with the new insolvency code, we have the same tools, let's say, confidential and non-confidential, in court and out of court. But something of new in the new insolvency code that complies with the rules of the European Union Directive is that to have more flexibility. Even Marta spoke about this flexibility to choose the tool that fits better to the situation of the debtor. There's the chance to apply for the procedure with a unique way, and then you can choose which kind of tool you want to perform. It was not in this way before for the Italian bankruptcy law, because you had to ask, for example, if it was something that needed an approval by the court, or that needed the appointment of a practitioner, an insolvency practitioner from the court. You needed to file the petition to the court concerning the specific tool you wanted to ask for. In this way, it's something of easier, because you just have one petition to file, and then from there you can decide which is the way in which you want to restructure your debts.
Thank you, Francesca.
You're welcome.
We had a question from the audience for Mylene. Happy to ask it. If France implements the European Restructuring Directive under the Sauvegarde label, would that mean that France doesn't require a change of Annex A of the European Insolvency Regulation to have EU-wide recognition, because the proceeding is already listed in Annex A? And if so, does it would mean that even though France is behind the Netherlands and Germany with implementation of the directive, it could be the first with EU-wide recognition of the new proceeding?
That's fully correct. Thank you very much for this very interesting question. Actually, I've never seen the question through this angle of view, but I think that would be correct. Actually, safeguard proceedings will be amended. I do not think we will change the name of safeguard. So it is already in Annex A of the EU regulation. There is one comment, because in the current draft, the government suggested to merge accelerated safeguard and financial accelerated safeguard. If the projects will remain this way, it means that we will only have one merge proceeding, and the name should be accelerated safeguards. So basically no need for us to change anything in Schedule A except deleting financial accelerated safeguard, but no real impact. But I'm happy to see that we would be very competitive with respect to the EU EU regulation. But I don't know. I guess that there would be a regulation to amend Schedule A shortly after July in order to have all new European proceedings created by the member states included in Annex A, if they also fit with the definition of insolvency proceedings pursuant to the insolvency regulation. I have no information about that, but I would be surprised that the Commission or the European Parliament will not do so shortly after July, which is a deadline for the EU member state to introduce the directive.
Thank you.
But if they don't, actually, it's okay for us, friends. We will be more competitive.
Yeah, indeed. Wencke, you referred to the role of a restructuring expert, a restructuring officer in your introduction. Can you tell us something more about that?
Yes, so the debtor can apply for the appointment of a restructuring officer when asking for the Stauung scheme. It is also possible that the creditors request the appointment of a restructuring officer, but then the creditors have to make up 25% of the voting rights of their group. And in addition, the creditors have to commit for paying the fees for the appointment of the restructuring officer. So I'm actually really curious whether a lot of creditors want to make that request or not. And also, the court must appoint a restructuring officers in some cases, in particular if the rights of consumers are to be affected in the context of the restructuring. If the debtor applies for a moratorium, which is to be directed against all or almost all of the creditors, and also if a cross-class cram-down is required. This is also a mandatory case to appoint a restructuring officer. The role of the restructuring officer is to moderate the proceedings and also to supervise the debtor's management. The officer reports to and is again supervised by the restructuring court. Any person who is independent of the creditors and the debtor and who is competent in business may be appointed as a restructuring officer. The debtor has the right to propose a specific restructuring officer, and the court may only deviate from such a proposal if the person proposed is not qualified. The creditors may also nominate a restructuring officer. Then again, they have to have 25% of the voting rights to make such proposal. Yeah, so that is the restructuring officer.
May I ask one question to Wencke? Wencke, you say that the restructuring officer can be basically anyone, any independent person, I guess. According to you, who will in practice play the role of the restructuring officer in Germany? Will it be the insolvency officer, Insolvenzverwalter, or any lawyer or even an expert accountant? Who will play this role in practice? And I guess this is a big question in Germany with respect to the role of insolvency officer in the restructuring proceedings.
Yes. So we actually expect that almost everyone who's an insolvency administrator right now will also see being qualified as a restructuring officer, and also probably lawyers who are not an insolvency administrator might be able to be appointed as a restructuring officer. Yeah, but we're actually also excited to see who is going to apply for restructuring officers.
I have another question for Wencke. And what if the restructuring turns out to be unsuccessful, and finally formal insolvency proceedings are commenced or opened? Is it foreseen? Is it expressly foreseen that the restructuring officer will be the same person as the insolvency practitioner in the formal insolvency proceedings, or will there be a totally different person who deals with the insolvency, different from the one that dealt with the restructuring?
This is actually to be seen. So how it is now is that the insolvency administrator has to be independent from the debtor. So it should the insolvency administrator should not be involved with the debtor before. But that this also applies for a restructuring officer then wanting to become the insolvency administrator. I actually cannot say that as yet. This is the decision of the court, then the insolvency court, who is going to appoint the insolvency administrator, whether they will see the restructuring officer as qualified or not.
Yes, because I think this is a key issue, because there are very strong arguments in the sense both of allowing and of forbidding that the restructuring officer is also the insolvency practitioner. But you have conflicts of interest, but then on the other hand, it's a person that will have a deep knowledge of the debtor business. So so let's see what happens.
Yeah, definitely. But you're absolutely right. Those are the different positions you could take on this, and yeah.
Can I get something, Lynette?
Sure.
There's something of similar in the Italian insolvency law, and we have cases in which you start a restructuring procedure and then you need, because it's unsuccessful, to switch into an insolvency proceeding. In this case, usually the Italian courts allow the same restructuring officer to become even insolvency practitioner, because he or she is independent, and even because you do not need to pass all the information concerning the debtor and the procedure of restructuring that failed to another practitioner. So this is our situation. We did not have many problems with a problem like this, except one: the remuneration of the insolvency practitioner. Because when you have to pay the cost of the insolvency practitioner, and he is the same that was the same restructuring officer, usually the remuneration of the insolvency practitioner entails even the part of the restructuring officer. So that's our situation.
This is very interesting. Thank you so much, Francesca.
You're welcome.
Thank you. Mylene, I understood in a previous conversation we had that in France, the introduction of creditor clauses has been heavily discussed. Can you tell something more about that?
Yes, sure. And just one comment before speaking about the classes of creditor. Robert Hennel says that the amendment of Annex A will take quite a long time, so that the German proceeding will only be in Annex A in July 2022. So thank you for this comments. Effectively, this is a key issue for the member states. This has not been many discussed in France, because actually we do not have this problem, but I guess it will be when we will make cross-border restructuring with all the countries, and there will be recognition issues. So to go back to classes of creditors, actually, even if we already have the restructuring proceeding to be amended, the changes will be rather important with respect to the adoption process of the restructuring plan. As you know, the the directive introduces the mechanism of creditors. Oh no, it's not. It's classes of creditors. Which is basically a similar mechanism as is existing already in the UK, in the United States, in Germany, so many other members, but which is absolutely unknown, or which was absolutely unknown in France. The process to adopt a restructuring plan in the context of safeguard proceedings, but this is basically the same in rehabilitation proceedings, is made in two ways. For big companies, I would say, with certain thresholds are met, the companies has to create creditors committees, which is quite different from classes of creditor. There are in France two committees of creditors, depending on the nature of their claim, I would say. On the one hand, there is the supplier committee, and on the other hand, there is the financial creditors committee. There can be also a third committee with bondholders, as a case maybe. But basically, the distinction is made between suppliers on the one hand and financial creditors on the other hand. Of course, then within each committee, you take into account differences between the situation of creditors, subordination agreements, intercreditors agreements. So in a certain way, the notion of interest was already taken into account, but not in the form of classes of creditor. So this was actually the main point discussed, I would say, during our consultation process debates about the directive. It was this classes of creditors, and we were particularly interested about what German or how German make restructuring proceedings or insolvency proceedings with classes of creditors. This was like a model to us, but we also look at English classes of creditors or Chapter 11 classes of creditors, etc. But there has been many exchanges between French and German insolvency and restructuring practitioners to learn more about how this mechanism happened in practice. It was really interesting to us. I think it was also good to have these exchanges with Germany in order to speak about our preventive system. So this was the kind of exchange we had. And now we continue having this discussion about classes of creditors. This is still something which appears challenging to us, and we will change our system in safeguard proceedings, but also in rehabilitation proceedings. But just one point about this, I think it will continue impacting big companies only. And for the smallest companies, restructuring processes will remain unchanged, I guess. We still have debates about the thresholds. But we see no need to change the processes for small and mid-sized firms with individual consultation processes.
Thank you, Mylene. Wencke, have there been similar discussions in Germany before implementation of the directive?
To be honest, I don't think so. We had the concept of classes of creditors in our insolvency plan procedure. So actually, I'm not aware that there have been any similar discussions.
Thank you. Marta, I understood from you that the rules on pre-pack or rules on sale of insolvent businesses have been discussed in Spain. Can you tell us something more about that?
Yes, this is really a pretty recent novelty in Spain, and it does not come from a legislative reform, but on the contrary, it has been the initiative of the commercial courts of Barcelona, which are they are known for being the most innovative judges as far as insolvency is related in Spain. Now they have come out with a protocol in order to translate, to implement a sort of a pre-pack into the Spanish market. Now the thing is, such as a pre-pack is not expressly foreseen in our Insolvency Act. So this protocol is it's useful. It's I have to say it's very, very interesting, but it poses many problems from its admissibility from a strictly positive point of view. Now, the thing is, they admit the possibility of appointing what they call an expert, which would be assimilated to a restructuring officer. But as I said before, this thing does not exist in Spain. And so this expert would be appointed before formal insolvency proceedings are commenced, with the aim of organizing the sale of the business. It's not purely a restructuring tool, unless, of course, the business is sold as a whole, and then it would continue its activity, but on the hands of another entrepreneur. So once the sale is organized, the proceedings commence, and as soon as formal proceedings commence, the commercial court authorizes the sale. So it's a win-win situation, because the debtor manages to sell the company very, very quickly, in a short period of time. The sale is carried out with the supervision of an expert, which is supposed to be independent. And also it has the authorization from the court, which also adds certainty to the operation. But as I say, this is a very creative and a very useful protocol, but it has left the country in a state of perplexity, because now, for example, we do not know if the commercial courts of Madrid or the commercial courts of Seville will allow for this pre-pack, since it has been originated in Barcelona. So we'll see again.
Thank you. That's very interesting. Francesca, are there similar rules on sales of businesses in Italy?
We have all this kind of tools. I just mentioned some of them before. We have other kind of tools that concerns, for example, debts with tax authorities or insurance authorities. So we have a lot of instruments that are different one from the other. I cannot say that we have something that is specifically similar to an UK pre-pack, or to the new instrument that has the Stazuk, Wencke, I think. And I think that any country has its own features, and this is the result of the harmonization of the European Union. Then we will see what is going to happen when we will have in all the European Union countries tools that are similar but different in the meantime. So we'll see what is going to happen and how the European Union directive will be applied in all the countries.
may I make one comment about prepackaged sale? In what Marta explained, to my experience from a French perspective, this pre-pack, in the sense of a prepackaged sale of assets, prepackaged sale of a business, are very powerful and very useful for debtors, because in this kind of matters, including a sale, time is of essence. As for a restructuring of debts, but I would say much more when you talk about a sale, because the insolvency proceedings or the restructuring proceedings, when they are public, they have a very negative impact on the value of the business. So the longer the proceedings will be, the more debate you will have with candidates, with potential buyers, and potentially the stronger the impact will be, unless you have a very good system to have to maximize the sale price. But usually the sale price are low, and having a pre-pack enabling you to prepare the sale, find buyers, discuss with buyers about the price in a very confidential framework, is very protective of the value of the company. So protective for the buyer itself, the debtors, the creditors, also with respect to the price that will be paid. I really believe this is a powerful tool to be used generally. You know, yeah, this is very useful in practice.
Thank you. The final topic I wanted to discuss are the measures that have been implemented in the field of insolvency law in light of COVID, and whether these rules are working or not. So Wencke, can you tell something about the rules that have been introduced in light of COVID in Germany?
Sure. So since March 2020, when COVID first arrived in Europe and actually became an issue, the German legislator has actually taken several measures to restrict the existing insolvency application regime. First, in March 2020, the legislator has suspended the obligation to file for insolvency, first until end of September 2020. The obligation to file was restricted, but not completely abolished, meaning that the obligation to file for insolvency was only suspended if the economic crisis of the debtor was related to consequences of the COVID-19 pandemic. Those included, however, both direct and indirect effects. Then in September 2020, the obligation to file for insolvency has been further suspended, but only for over-indebtedness. So if a debtor was illiquid, he would have been obliged to file for insolvency again. This suspension for the reason of over-indebtedness was suspended until end of December 2020. Again, it required a causal link to the COVID-19 pandemic. Currently, the obligation to file again has been suspended for companies who have filed for an application for financial assistance under the governmental mitigation assistance programs relating to COVID-19 until end of April. So currently, the debtors who are struggling due to COVID-19 are benefiting from the suspension of the duty to file for insolvency, and they do also have easier access to protective shield proceedings and self-administration proceedings, as well have a shorter prognosis period for the test of over-indebtedness, meaning the period of 12 months was reduced to only 4 months.
And Mylene, what about what has happened in France?
Many measures. Just to focus on one of them. No time to speak about all the government did and still continue postponing. the duty to file has been suspended too, basically from March to the end of August. But actually, I think the way it has been done was not that bad, because the duty to file has been suspended, but debtors still had the possibility to file, okay, for any proceeding they would like to. Creditors could not file for hostile proceedings, public prosecutor neither. And actually, there has been a strong incentive given to debtors to go to preventive procedures such as mandat ad hoc and conciliation proceedings instead of formal public restructuring proceedings such as safeguard rehabilitation and liquidation. Actually, we had less proceedings opened. I heard minus 30%, minus 40%. I am still unclear whether the number of preventive proceedings, mandat ad hoc and conciliation, increased or has been reduced. I have received contradictory numbers. I know that in Paris, at least, the number of preventive proceedings remains stable. And actually, what we have seen is that it was mainly big groups, big firms, which went to courts and used this process. So, meaning that it was good for them. I don't know if it was a good thing, a good sign that many other companies, including mainly small ones, abstained from filing or going to courts to request preventive measures. I think we will have an answer potentially this year or next year in terms of increase of proceeding and restructuring frameworks. That's the big question. I do not have the crystal ball and I will not do any prognostics to this tech, but let's wait and see, yes.
But have the rules on directors' liability also been suspended?
The rules about liability?
Mm-hmm.
Yeah, no. That's, I think, a big problem. At least, you know, there have been, I mean, the idea, the philosophy, the ratio legis was to incent debtors not to file and continue their business even if they made losses. But, you know, the French Insolvency Code also provides for rules according to which a debtor continuing the business while making losses can be held personally liable in case of subsequent liquidation proceedings. So what we see is that there has been no mirror rules related to the liability of directors, and actually organizations would like to take steps, inform the legislator, the government about this issue, because you know, usually liability actions are initiated in the context of liquidation proceedings, and as a matter of practice, by the end of the proceedings, not at an early stage. So approximately after 2 years or 3 years after the opening of liquidation proceedings. So it means that in 2 or 3 years, litigation cases involving debtors related to the situation now will start. And in 3 years, you know, we will not really remember what happened, or it is possible that once things turns bad and that the company will be liquidated, we will have the impression that the debtors made mistake. you know, you always make the story again, in the sense it is not favorable to the debtors if the company has been liquidated. So to us, at least to me, it is really important that the government would take measures, potentially legislative measures, in order to comply or to answer this issue.
Thank you. And Marta, can you tell us something about the measures that have been introduced in Spain?
Yes, well, as Mylene did, I will go very briefly through these measures because there has been a lot, and I'll focus on a couple of them. Now, all the measures that have been adopted in order to deal with the COVID crisis can be organized in 3 blocks. Now, the first block would refer to measures that aim at avoiding the destruction of viable companies. The second block of measures would refer to enhancing the access of companies to financing. And the third block of measures would refer to the ones that aim at speeding up insolvency proceedings because the authorities feared that due to the crisis, the commercial courts would collapse. So some measures in order to accelerate the proceedings have been adopted. Now, from all these measures, I would like to focus on 2: the suspension of the duty to file and the requirement of the viability of business. Now, as far as the suspension of the duty to file is referred, our suspension, our moratorium will end in 11 days, the 14th of March, because in Spain, the state of alarm was declared the 14th of March of 2020, and in 11 days, the moratorium will end. Now, today, we don't know whether this moratorium will be extended or not, because there are rumors in both senses. There is a very strong position in Spain that says that the moratorium has to be lifted, that the suspension of the duty to file has to be lifted, because I mean, if companies have been suffering up to date, now it's time that they go to a liquidation in order to avoid further damages. And on the other hand, we have the opposite position, in the sense that let's extend this moratorium a little bit more, based on the grounds that Mylene pointed out before. Look, it's not a prohibition to file. Debtors can indeed file for insolvency. Creditors cannot, but debtors can. So if they want to, they can. You know, I carried out an informal survey on Twitter, and and I asked whether people thought that whether the moratorium would be extended or not. And the option that got more answers was the one that said, yes, it would be extended the day before. We will receive notice that the moratorium has been extended just the 13th of March. So and this poses a problem because it leaves no room for planification. Now, when debtors come to you and they ask, should I file? Should I try to reach an agreement with my creditors? We are unable to provide sound assessments if we do not whether this moratorium is going to be extended or not. This is the first point I wanted to make. The second point I wanted to make is that the vast majority of the measures that have been implemented in Spain as far as COVID is related refer to viable businesses. But then we have a big problem in determining which companies are viable. Who determines that? Because other debtors that unilaterally decide if they are viable or not. And because in my opinion, the viability should be assessed by a third party. But then again, we enter in another, we face another problem, is that who pays for this assessment? It's not a cheap task, and it takes time. And Another problem regarding the viability is that it is not explained in the law whether these measures can also be profited from the companies that were not viable before the pandemic started, or that whose problems started before the pandemic. Because what we have now in Spain is that some businesses that had problems before the pandemic are profiting from these measures. I fear that this will have consequences as regards the liability of directors, again, as Mylene pointed out, because this has not properly been addressed. And I think, and I fully agree with Mylene, this will surface at a later stage, and we will have to deal with it later, because for the moment now, in Spain at least, it's a problem that had been left aside. To deal with bigger problems, I agree with that, but it's something that will need to be dealt with in the future.
Thank you. And Francesca, what has happened in Italy?
In Italy, we had a lot of law decrees too, facing the COVID pandemic, with a lot of provisions. We had the temporary deferment of bankruptcy of filings or requests, except in the case of voluntary petitions that were, let's say, where insolvency was not attributable to the pandemic, but to something of external, different from that. And we had the same that situation in which the so-called rule of recapitalize or liquidate rule has been suspended. So there was fact that the capital had a reduction pursuant to losses, was let's say freezed for a moment, for a period for all the year of 2020. And then we had even something else of really strange, in my small opinion, that has been on the financial statements of the businesses, but this means even on a possibility of being insolvent, of being in distress. That is the jure assumption of going concern for all the businesses for 2020, if they had the going concern before it was February 23rd of last year. And this is really strange, because it means that even if there is no chance to have the continuity of the activity of the business in the year, you still have this provision of the law. And I think that this is another aspect that we will face in the next years, in 2021, but even in 2022. And we had the same problem, always in my opinion, with the liabilities of directors, because it is not being managed by the Italian government during the last year. And they say that it depends on the wrong misconduct of the directors, but who is gonna decide if there was a wrong misconduct or not, if it was a problem due to the pandemic or due to the way in which the directors behaved. So there are many problems, I think. There were temporary provisions just to cover only some little aspects, but we will go through this COVID pandemic in, I think, 2 or 3 years, if we have to think about everything, all the consequences.
Thank you very much. Thank you very much, Marta, Francesca, Wencke, and Mylene for joining the panel today. I think it has been a super interesting discussion. And thank you very much to the organizers for organizing this this panel discussion. And also many thanks to everyone who joined us today.